Hi, everyone, and welcome to our webinar, Global Energy Governance, Problems, Pathways, and Next Steps. I'm Ryan From-Pizzulli, Program Manager for the Institute for Energy Law, which is an institute of the Center for American and International Law. This webinar is hosted by IEL's Academic Outreach Committee, and this is the first of two sessions we have planned on renewables academic topics. The second topic will be on regulation and development of offshore wind energy projects in the US and Europe on January 8th. Please welcome our two speakers, Abby Cohen-Smutny and Professor Frederick Sorgens. Abby is the global co-head of White & Case's award-winning international arbitration practice. Her experience includes banking, financial services, oil and gas, mining, electric power, real estate development, water supply, retail, pharmaceuticals, construction, tobacco, railroads, telecommunications, and manufacturing. Freddie is the James McCulloch Chair in Energy Law at Tulane Law School and Director of the Tulane Center for Energy Law. He regularly speaks and publishes on international energy law, international dispute resolution, and transnational law issues. Freddie is the co-lead investigator of the Energy Transition Policy and Regulatory Briefs projects for the Organization of Petroleum Producing States, OPEC, and the chair of IEL's sister institute, the Southwest Institute for International and Comparative Law, or SWICL. I'll now pass it over to Freddie and Abby.
Thank you so much, Ryan. And again, I'm really looking forward to everybody submitting questions in the Q&A if we have time to answer them. And as we can ladle them in, it would be great to have everybody come in as well. One needed disclaimer right at the front. The discussion that we're going to have obviously is not meant for attribution to any of our institutions, clients, or in my case, students, and is at times also intended to be thought-provoking rather than to necessarily provide our own viewpoint on issues so that we can elaborate what is going on in the broader energy space. We're going to have kind of three parts. I'm going to do a very quick setup about how it is that we got to where we are today in the international energy space. And then we're going to explore together, what are we going to do now that we are in this space? And what are the pitfalls and things we need to think about in terms of those steps that we can take to better protect ourselves in the international energy space? So let me quickly share a few slides just to get us to how it is that we got to where we are today. We need significantly more energy than we ever needed before, at the same time as we need to decarbonize energy inputs. And both of those things happening at the same time is something that presents an increasingly important challenge for world society. And it's a challenge that involves energy cycles and innovation. And these energy cycles and innovation begin when somebody has a bright idea about how it is that we can do something better. And you have at that point an eruption of a new technology that shows that it can solve a problem much better, that then leads people to come in a frenzy stage to kind of jump onto that and say, okay, I want to do that too, because there are significant profits that are available in this context. But at the same time, you also get a misaligned incentive structure at that point, potentially between what the market will bring and what the players want to get out of it, which typically draws the regulator in to modify how a market functions, to realign the incentives in such a way that we get to a mature energy system that really provides the most efficient delivery of a particular technological paradigm, which then kind of leads us back to, well, now that we've done all of this, how do we solve the next critical problem? And the key thing that you see in this context is that when you map what model of regulation works at what particular stage, you will see that when you first get an idea, a utility private public model is a really good model to use because it spreads risks in a way that allows the innovator to have security of returns at the same time as it allows the public side to get the benefit of a particular model, but that as you start getting further and further downfield with that model, you can get bubbles that form. And arguably in the renewable space, when you had feed-in tariffs, that is something that happened, where you then have a regulatory intervention that could either move in the direction of liberalization of markets, as happened in the US in the 1990s and as happened in Europe a little bit later, or you could have a command approach at that point that says, no, 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 the government takes it over, as happened in the 19 teens in Germany, for instance, and that's kind of how you roll this through a regulatory paradigm where you see that, well, there's political risk that forms. And the problem is that as you have these domestic regulatory responses, you have these unintended global consequences that come from that. When you start a new energy system, new energy solution, you typically have pretty short supply chains. So you produce most things really close to where you deploy the new energy solution. Whether that was coal-fired power plants in the late 1800s, whether that was solar in Germany in the early 2000s, the supply chains in the beginning were really short. But the moment that this takes off, you start sending these price signals out into the world that there is a market here to be captured. And so people are then going to use their relative advantage in their respective positions to enter this marketplace. And when the frenzy comes to an end, you get a global consolidation that leads to a highly complex, globalized supply chain where you really place most parts of the supply chain where it is most profitable for people because of the relative advantages of location. And that leads to significant consolidation in these supply chains in a way that reminds us of Ross Perot back in the day that says, look, if you thought that you had these supply chains domestically, by the time that you have this globalized supply chain, a lot of these production processes are simply going to move abroad because they are cheaper, they have better access to needed raw materials. And so, in the end, the only way that you can rejigger this is if you innovate yourself out of that by providing a better solution to, again, get the price advantage. But the problem there becomes that innovating yourself out of a problem is easier than it sounds. And so now you're stuck with these consolidated supply chains globally that create real realpolitik challenges in that you have an ability of key players to exert significant influence over core parts of supply chains that everybody needs. And the moment that happens, you land in kind of these unstable realpolitik equilibria. All power is relative. In as much as it's if you're looking at the ability of states to influence and gain influence over each other, that's a zero-sum game. And while states tend to like to get control and dominance over significant supply chains, in the end, it is much more a game of denying control to others, because denying control to others is something that gives us greater autonomy over our own energy systems. And the problem in the energy sector is that, and this is kind of where we landed right now, is that if you make imprudent bets in the context of realpolitik assessments, you may end up in really untenable and dangerous positions geopolitically. Um, so these imprudent realpolitik moments remind me certainly of the speech by President Jimmy Carter about the moral equivalent of war with regard to oil embargoes. Um, but just as importantly, also tease up the Nord Stream and Nord Stream 2 discussions in Germany's context, where a bet on a continuation of good relationships as Ostpolitik in Germany kind of started in the 60s and 70s and got close to the Soviet Union. There was a bet in Germany that we can continue to work with Russia now and use these investment flows and gas flows as a means to pacify relations and to diffuse relations or diffuse the conflict potential in relations. And as we stand here today, that obviously didn't happen, but rather provided the leverage to the Russian Federation to use in a realpolitik play in the region. So as we're looking at energy systems today, we really find ourselves at a point of, we need all manner of energy inputs, and yet these energy inputs have consolidated in all manner of places and are inefficient in all manner of places so that you get domestic responses of market liberalization at the same time as you get international responses to uh, really put a greater premium on energy security, which both really have a whole ton of uncertainty built into it, both as political risk and as geopolitical risk. So that's kind of where we are in terms of our starting point. But if you're wondering, well, how did we end up here with energy disputes potentially blooming or energy opportunities blooming at the same time? So, with that intro, Abby, let me just ask you, what are the kind of things when somebody says, "Hey, I have this great investment opportunity in country X, and it just liberalized its pick its energy related sector. What is it that I ought to do to make sure that nothing bad happens to me, or to the extent that that risk is there, that I can mitigate that risk? How do we deal with it?"
Yeah, so I would just underscore, to begin the point after, the explanation that you set up, that I think we all understand that the amount of investment that we need in energy generally is just massive, that we're not going to reach any of our goals without really a tremendous amount of private investment. And so we are going to need investors, energy companies, investors that want to invest in energy companies to be willing to deploy that private capital into energy projects, more energy generation. And, at least there are a couple of different ways to think about this because there are different energy sectors. So we could think about extractive industries, fossil fuels. There are still investments needed in fossil fuels. But when we think about extractive industries or investments designed for energy, it's not only in fossil fuels, it's also in all of the minerals that mining, basically, all the minerals that we need for energy transition and other types of technologies or technologies that we need for energy. So there's a whole category of investment that by and large depends on still concession contract with a state. So I would say that the first thing that we need to consider is the sustainability of the terms of the contract in the first place. So that, the more imbalanced or unsustainable the contract provisions are, the greater the likelihood that dispute will arise. So first, we can think about the importance of sustainable contractual provisions, to begin with. And we are seeing, I think, over the last couple of decades, an increased sophistication on the part of state actors in negotiating these concession agreements. Arguably, that's a good thing in the sense that they're more likely to be balanced. But even in the best balanced example of a concession contract, we're still facing the possibilities of resource nationalism, which just doesn't go away, and other issues. So, considering let's just talk about the realm of concession contracts before we talk about power, and power generation. So, concession contracts still, you have the opportunity of directly contracting with the state. The arbitration clause still is over time the most likely reliable means of dispute resolution. It's far from perfect, but the idea of relying on the local courts is very often not realistic and is not going to attract um, confidence. So, still, a concession contract, arbitration clauses, really important. An arbitration agreement with the situs of arbitration outside of the jurisdiction of the state actor really provides still the most important type of protection in that context. So I would say these are basic observations, but still really very important. Um, but now let me also talk generally about investment treaties. Of course, contracts, I think, are easier to have an arbitration about than investment treaties, but it's always a sort of boots and suspenders approach when you have an opportunity also to attract the protections of investment treaty. It means thinking about the ownership structure of your investment. Sometimes investment, requires a locally incorporated company or a joint venture in which you're the minority shareholder. There are a variety of reasons why having the boots and suspenders, so to speak, I'm sorry, belts and suspenders, so to speak, of the investment treaty is still really important. So contractual agreements plus investment treaty. Um, maybe let me just stop there for a moment because then I think we can have a separate discussion about how do we deal with investment in regulated industries because it's a little different. I think the observations are a little different, although equally important. So should we comment a little bit more,
Yeah,
Freddie, about, let's say just the extractive industry, the mining, the power, oil and gas? Uh,
let's begin there because I think, as you say, there are different concerns that you will see in the extractive context.
yeah,
And what we've seen in the past is both kind of the windfall profits
yes,
argument that was made that, if the prices go too high, states
yes,
say we are owed more of an upside participation. Of course, I'll note that in low price environments, they very rarely say, oh, now that the shoe is on the other foot,
right.
we're going to give you more money. That tends not to be the logic. But, let's leave that aside for a minute. Um, so you have that as a whole separate set of concerns. The two things that I think would be really interesting to talk about in this context are how are contracts and treaties different in terms of the protection that they provide in the extractive sector? Because if I have a great contract, you know, one of your clients might ask you, well, what does the treaty give me on top of that? Like,
Right.
why should I also want to consider a treaty structure or a treaty case in case that, there has been a change, like an introduction of a windfall profits tax?
So, couple of things. One, who is the counterparty? I think it's important to consider that not every state-owned entity is necessarily going to be equated with the state as a whole. And there may be times in the context of disputes that having the ability to complain also to the state, not only to the state-owned entity, provides a different type of protection. So one type of protection is not better than the other. I would say these are, in our Venn diagram, these are overlapping sets. So it's about expanding the types of, let's call them protections, but it's a really a way of at least addressing potential disputes that are different. So the counterparty may be different. That's one issue. The governing law may be different. Your concession agreement, your typical concession agreement is typically governed by the law of the host state, and the international investment treaty is typically giving you protections that emanate from the treaty itself, international law. So again, these could be seen in some ways as overlapping, but it's expanding the types of protections that you might have. So counterparty difference, governing law difference, and then the nature of the obligations of the counterparty are going to be different. So the contract may be, in some circumstances, really wide-ranging, and it may cover very many different types of obligations of your counterparty. But it's very often not entirely overlapping with the types of obligations that the state is providing in the investment treaty context. So I would say, with almost no exception, very few exceptions, these are ways of expanding the nature of circumstances that could give rise to a claim. And it's just about expanding. If you have contractual provisions, that's terrific. It's very often enough, but sometimes it's not enough. It's interesting to talk about the concept of a stabilization clause. What about changes of law? Bear in mind, the concession agreement is usually governed by the law of the host state. Am I protected in the context of a change? The state wants to change the law. Stabilization agreements are not necessarily standard in these agreements. And if you don't have a stabilization clause, an agreement that laws will not change, you cannot assume that you have them. And the investment treaty, people assume that you have protections against regulatory changes or changes in a tax regime, for example, or change. Not necessarily. You have to really be careful about that because the investment treaty protections are typically only going to secure specific undertakings that have been given in an undertaking that one would reasonably expect is going to be binding. And so, if you have an express stabilization clause, well, great, then you have a contractual protection, arguably. But then you get, again, you have to think about it's a fun, complicated area because if your contract is governed by the law of the host state, you get into issues of, the legality of provisions, including stabilization agreements. It's an example that if you have a stabilization clause, the investment treaty provides arguably a different level of an additional level of protection. So those are some of the principal points that we think about. How do you expand the protections?
I mean, this is one where there was an interesting discussion going on a listserv just today. The listserv is called OJIMID. Um, and there was this great question as to whether arbitrators could just ignore the law to the extent that they felt like something was unfair. And in the context of stabilization clauses, that becomes something that is really a thorny issue, right? Because say there is a state Supreme Court decision in the jurisdiction where the stabilization clause was concluded and that governs the agreement, and that state Supreme Court decision says, no, the stabilization clause is against public morals and is void ab initio. And now you have an arbitration that is subject to that law that enforces the arbitration, that enforces the stabilization clause and says, no, no, no. That Supreme Court decision itself is problematic. We don't trust it. Well, now the cat's amongst the pigeons, isn't it? I mean, did you
Yeah, and
apply the law? Did you not apply the law?
yeah, look, I mean, you described the garden variety, the classic problem of having a concession agreement. It has a stabilization clause promising the law is not going to change, the tax regime's not going to change, whatever provision, the economics are not going to change and the law will not change to undermine that. And you have this express and you're feeling really very good about it, except your contract is governed by a national laws. And then you end up with a court decision that provision is unlawful. That's the classic example of where reference to international law principles classically captured in the investment treaty context are intended to provide uh, a protection against something like that. I mean, and you can have wonderful debates about whether it's reasonable to expect that, if you agree to a concession agreement that's governed by a domestic law and there's a provision in the law in the contract that's arguably unlawful, still people debate about this, but the issue is whether or not, for most arbitrators, the issue is whether or not one could reasonably expect, whether there was a reasonable reliance, whether there was an intentional, inducement of reliance. And these are the principles that the investment treaty is intended to address whether it was reasonable for you to think that you had protections against changes of law or not. And there are certainly circumstances where I think many would say, yes, you were given a specific assurance in a contract. You ought to be able to rely upon that, even though you accepted the law of the host state around that. So, but this is the debate. I think, you're never going to have a unanimous acceptance of what the rule should be in a situation like that. Decades ago, and I don't know that you would expect to see it today, you would have concession agreements that themselves included, were governed by international law. I mean,
Mhm.
I think you don't see that very often today, but if you did, then the nature of this discussion is different. That, of course, is a great sort of protection. If your governing law is not limited to the law of the host state, of course, that's always from the investor's point of view. Terrific if you can get that the concession is governed by the law of jurisdiction X and principles of international law. States, and I refer earlier, states tend to be more sophisticated nowadays. I don't think you often would see that, or you certainly would start, the state would start off arguing against that type of governing law provision. So this is a classic and important issue, but just underscores why having that investment treaty protection, if you can structure it in such a way, gives an extra. Nothing is guaranteed, right? There are no assurances. Arbitration doesn't always work. In the sense that, you might not be able to persuade on your position, but at least it gives it's de-risking, but
Yeah.
not doesn't eliminate, it reduces risk. Courts, arbitrators, nothing is perfect.
And just to follow up on that, that's where the site of where your arbitration is and what law governs the arbitration might very well be critical, right? I
Oh,
mean,
absolutely, right? Because, whether you have really independent courts, whether you have sound institutions that have the capacity and the level of sophistication needed. So sometimes it's about that. Other times, unfortunately, it's about corruption. And we have to be realistic. And it's not only the state actors that could be corrupt. Of course, we know that some investors are ensnared in corrupt circumstances, and so but when you're thinking about how to structure, you do need to be realistic about the capacity and the independence of the court system, and for sure.
and I
That's an
think
issue.
you also get some jurisprudence in some states that tend to look at an internationalization of the contract by the time that you have an international arbitration introduced, which would mean that the argument that this is a non-application of law would be less likely to fall on fertile ground. And there are some jurisdictions that are much more literalist. So, and these things change. I mean, France used to be a much more pro internationalization jurisdiction. Question whether that will hold to the extent that we have more disputes where the EU's own policies are coming under scrutiny, or whether then you would have a change in a French attitude to those kind of things. So, I mean, it's just important to know what one is getting into because we're mitigating risk, we're not eliminating it. And the more information you have, the better.
Right. And choice of form is not necessarily choice of law.
Hmm.
So these are different. I think, there's a greater understanding that these are different concepts, and form does not necessarily entail choice of law. So one needs, ideally, to maximize the reduction of risk, so to speak, on that point, appreciating that choice of forum is different from choice of law. Whereas maybe before, decades ago, there was a greater willingness to equate one with the other. And I think that might have contributed to a sense that part of the backlash that then one saw. I think, overstepping um, on these issues, I think caused some to bring some reasonable criticisms. And so that doesn't mean that there's anything wrong with changing choice of law, change of choice of form. I think it just calls for one to be more precise in the drafting and more transparent about what it is we're agreeing to. And that assists, of course, in in the security of the agreement itself, the more transparent it is in principle.
And I guess one last thing that is important before we can kind of look then at the regulated
Yeah.
sector is when you find yourself in a dispute, I guess you want to make sure that people that you put in charge of that dispute, both as your counsel and as your arbitrators, are actually up for it because there have been no end of scandals about, quote unquote, fake arbitrations where the evidence was less than stellar and probably untruthful as to what was alleged in the underlying case. And so I think those things you fix by having excellent counsel and excellent arbitrators to uh,
Yeah, and
that.
of course, yeah, a few bad apples spoils the whole bunch. But yeah, of course, it's important when thinking about arbitration agreements to choose an experienced and established arbitral institution. I think, a set of arbitral rules still important. The idea of having ad hoc arbitration is risky. I would say it's less risky to choose an established arbitral forum. It's less risky to choose, of course, you should always choose your counsel carefully, but choose arbitrators carefully, of course. But another point about all of this is you want to minimize to the extent you can the likelihood that you would have fighting about the enforcement of the arbitral award at the end. So all of, a choosing well along the way minimizes the extent of potential disputes about enforcement even after you have an arbitral award. These arbitral awards are not subject to appeal, and so some of them are some will be good and some will be less good. We cannot appeal them. That's something to consider. But that goes back to choosing well the arbitral institutions and the arbitrators.
So we have a question in the Q&A that I will that'll adapt a little bit because as we move over to the more regulated side, um, there's sort of the question of to what extent um, is the environment such that people on the electricity side really should take a leaf out of the extractive side and just insist on a contract. So in the European context with renewables, there frequently wasn't a contract in place. And to the extent that you find yourself in investments in the United States, frequently there isn't a contract in place that would guarantee um, the continued payment of whatever support one would have expected under tax law. Um, so, um, how important is it that one have a contract and that electricity just act like oil and gas and mining?
Yeah, so there are a lot of segments to the power generation, power supply system. So there are a lot of steps in the process, but let's just talk about power generation first, and then we can talk also about um, we can talk then about power, supply and distribution. But in terms of very often you're talking about investment into a regulated market. You might not have, as you say, you might not have an opportunity, just the nature of what you're doing might not lend itself to any meaningful contract with a state actor. Maybe yes, maybe no, maybe there's a power purchase agreement still, it's possible. So sometimes you're investing in power generation, let's say, and you don't have a contract, but you are dealing with a regulator. You are dealing with a regulator, and a regulator is either determining or at least influencing your prices. And these are prices that are not necessary, for an end user, the consumer, the state is not even the one to be paying. So it's really a situation in which you are very vulnerable to political risk that comes with the fact that the end user is paying the price for the electricity, which is being set by a regulator. And so if it becomes politically desirable to lower prices, you do tend to see a regulator maybe being vulnerable, potentially vulnerable. Of course, they're not supposed to be. They should be independent, but in some jurisdictions they might not be, or there would be concern, are they not acting independently? Or maybe there's just a sense that the regulator is not itself acting fairly. All of this underscores that in principle, the possibility of an investment treaty protection brings some value. Is it a perfect solution? No, it's certainly not. But it brings some level of protection. So whereas before we were talking about, when you clearly have an opportunity to have a contract with a state actor, you have an arbitration clause, it gives you something. It's around the subject of the contract. But when you're subject to regulation, your whole business model depends upon a regulator acting fairly in a context where there may be political risk. The opportunity to have protection from an investment treaty is really important. But what we see coming out of Europe is it's far from a perfect type of protection because it's just really very messy. And then we can start maybe talking a little bit about that. But just going back to does this mean you should at least try to get the benefit of the investment treaty protection? All else being equal, of course you should. It's additional possible reduction of risk.
One thing that makes this so front of mind today is you pick up the any newspaper, really, the New York Times, Wall Street Journals, and both of them have kind of had headlines and stories about price of electricity is the new price of eggs. And to the extent that you want to do something about the price of electricity, a market liberalization approach is going to take time. And electoral cycles run much faster than the investment cycle to get to commercial operations of a new power plant that could bring down prices. So the obvious temptation, wherever in the world it would be, is to not freeze the rent, but freeze the electricity price. At which point you might find yourself in kind of precisely this territory anywhere around the world, not just in the United States, where these pressures that come from increased demand from data centers on prices at the same time as you have consumer expectations of lower prices could really put us right in the middle of these very types of disputes, not in a law school exam hypo, but in an ICSID case or in whatever proceeding one would have if one doesn't have access to investor state protection. Are you seeing it? Is that, I mean, if you can talk about it, is this something that people are already talking about, or is this something that is still kind of, well, you're looking around two corners from now? We're not quite there yet.
Yeah, I mean, I think most of these disputes, it's still, I think, the case that the majority of the disputes in the sector come out of situations in which some type of economic incentive was put in place to encourage investment, to encourage increased investment. And then what happens over time, as you were describing in the early slides, inevitably costs change over time and sometimes pretty quickly. And so it's not surprising that sometimes on day one, an economic incentive that felt necessary, on day three suddenly feels unnecessarily generous. So, and so how does one deal with those situations in a fair way? Most of these disputes come out of circumstances in which an incentive was given, economics arguably change, the incentive is deemed not necessary. There's a political sense that therefore end users, the consumers, are now paying too much for electricity. And so there comes the question, can the regulator end the incentive? Can they withdraw the incentive? And the answer to that question depends on, well, in what way was the incentive given? What were the terms of the incentive? In what instrument were they given? Was this an incentive given in a contract? Was it an incentive articulated in a law or in a regulation? And then you end up with very interesting debates about whether or not, if an incentive is offered in a regulation, is it reasonable for an investor to think that the regulation cannot unilaterally change or not? It's one thing to say, I have a contract, you then have some understanding that one party is not unilaterally changing that contract. If you have a regulation that gives a very specific sort of incentive, but it's articulated in a regulation, is it reasonable to expect that the regulator cannot unilaterally change because regulators are normally permitted to change regulations? But that's a question that is the subject of these so many of these arbitrations, and they are not unanimous in the way that arbitrators see it. Some arbitrators consider this regulation was clearly intended to induce my reliance, and therefore to change it is not fair. And others look at the same thing and say, it's a regulation. You should have known better. And so the interesting discussions around fairness. So I think, for our audience thinking about it, I think I find it helpful to consider how is what are the terms of the incentive? What is the law governing that incentive? How and through what instrument is that incentive being given? And then to consider evaluating the risk accordingly. But that's really the heart of what so many of these cases are about.
So then you get to this problem of, well, I can't exclude the risk, right? I mean, you operate in a regulated market, and so now your question is, how do I appraise this risk? And it would seem that at this particular point in time, risk is simply greater across the spectrum, across all jurisdictions, that, things may change, which means prices would have to change too, because if risk goes up, my return needs to go up in order for me to accept the risk, which is going to bring the price of electricity even higher. So if we would all agree that we would keep to our regulatory outcomes, I think we would have a more efficient outcome in the end that would bring prices down. But it's just difficult to enforce because we kind of have the dog chasing the tail a little bit. Um, and what I wanted to kind of come to next, you mentioned the European experience. Um, it, there is, and I mean the United States in its arguments in NAFTA and USMCA filings has kind of made similar arguments of, look, the thing you thought was a protection is actually not a protection because there is some other way of looking at it that says that there is another legal interpretation of these protections don't apply to you and can't apply to you. So in the EU context, you have um, the argument that EU law supersedes bilateral investment treaties, um, and how can how should one make sense of that potential? Like, what are the two sides of that? To sort of look at it now in hindsight, the two sides, and how should we assess that going forward in a new investment opportunity?
Yeah, look, I mean, that's very difficult, and you hope that that sort of clash of legal regimes doesn't happen again, because I think uh, it's it's uh, it's hard, I think, to disagree with the idea that there's really a disaster, I think, around that. On the one hand, I understand that the European Commission's position is we have a treaty regime governing the European Union, and it is a creature. Our treaties that form the European Union are international law. These are treaties among states, and they're not hierarchically inferior or superior to other treaties that may exist. But we have a treaty system, and one of the organs of this treaty system, a creature of the treaty system itself, is the Court of Justice of the EU, and it has the power to interpret the treaty and the obligations of the parties under this treaty. And so the view taken there is that the investment treaty regime is not applicable in accordance with the understanding the terms of the European treaties, and it's a question of which treaty was concluded in what sequence, and so there are arguments that are made that I think a lot of people have a hard time accepting, that the decision of the European Court of Justice is really functionally a treaty interpretation. And it's not an example, they would say, of national law or quasi-national law taking precedent over international law, but rather clash of treaties, which should be interpreted under the principles of Vienna Convention on Law of Treaties. Anyway, how did anyone foresee this? Is this fair for dozens and dozens of parties, including arguably states, who believed that they had a regime that was applicable, and then later for there to be a decision that it was not applicable? I think is really just very difficult in terms of expectations. Is that going to happen again? Is there going to be another circumstance in which that happens? I hope not, because I think that one thing that many struggle with is the lack of foreseeability of such a clash, so to speak, of regimes, and the transparency. I think it's difficult. Nevertheless, um, the decisions are what they are, and they are, I think, understood as treaty interpretation decisions.
Mhm. I mean, you say, will something like that come up again? I mean, the thing where I keep scratching my head really it's a chestnut. So when I'm scratching my head, I'm not saying, I've made up my mind either way on it, is you now have states saying that if a sanctioned individual brings an investment treaty case against a sanctioning state, that would not be recognized as an appropriate use of investment treaty arbitrations, and that those arbitrations would be, enjoined or their awards not enforced. I mean, that seems to me like another one of those, like, well, was the system built for this? Who knows? But you have like these clashes that keep coming from the geopolitical tension that is in play on energy, that hopefully we don't see many more of these, but it seems like we keep ending up with unintended consequence after unintended consequence, where we're then trying to figure out, well, how good is this protection mechanism? Um, and
Yeah.
how do we make it, how do we strengthen it at the front end? So if somebody said, well, how do I structure this if I wanted to make sure that I have a better protection against these kinds of circumstances? Is there anything we can do?
Yeah, I mean, I would start again emphasizing that the investment treaties are not panaceas. Litigation is not, a panacea. And the ability to bring a claim and the ability to seek compensation for a tort, is almost never complete, really compensation. It's just so it's highly imperfect, but it's the best we have in circumstances in which there's a dispute or a problem. So, can we make it better than it is? Well, maybe we can. But I think, for those who are entering into these transactions, I think the best you can do is ensure that you have as many potential avenues as are out there to provide a possible means of mitigating the risk, and that doing that should mitigate. It will not eliminate. It can only mitigate risk. And will it work? Well, maybe it will, and maybe it won't. There are limits. The law cannot solve every problem. That's for sure. And bad cases establish bad precedent. There are limits. We cannot, fool ourselves into thinking that through the work that we do, we can solve all problems. We cannot. Um, so all I would say is that paying attention to the structure of the transaction, the law governing it, the available mechanisms for dispute resolution should a dispute arise. Is there a way to have an investment treaty protection? Get it if you can, but don't think that it's going to solve every problem. It's only, an option. Sometimes I hear, discussion or get questions about political risk insurance, which is another vehicle through which one may consider minimizing risk. Well, that may or may not be a good solution. Um, for especially small and medium-sized investors, it might be cost prohibitive. It's basically the costs up front for again imperfect coverage, but it's something, not having political risk insurance. Arguably, you have the costs come later if you have to have the fight, and the more that you pile on costs up front, the more expensive the investment becomes, the less likely investment will be made. So there's no perfect solution, but there are a lot of possibilities out there for trying to mitigate the risk.
Mhm. One thing we talked about when we prepared the call was kind of the structuring costs. So, you could build the safest car that would never lead to any road fatalities. It would just cost $200,000 per unit. And it turns out that that is not a cost that is socially appropriate when people need to drive places. So could you talk some about how should I, now that I have all this, in the back of my mind, okay, there's risk. There's risk I can mitigate to a point. There's risk I can't mitigate to a point. How should I approach the cost of structuring to gain better protection versus the benefit that it gives me? How would you approach that?
Yeah, I mean, look, these are difficult business decisions. If structuring, a structure that provides investment protection is not always feasible for a given investor. It really depends because sometimes establishing an entity, sometimes you have an investment protection available to you depending on the nationality of the entity that is making the investment and the host state for the investment. Sometimes it's easy, sometimes it doesn't take much. Sometimes you have investment treaties available that don't require an expensive restructuring. What ends up happening for most clients is that when they are considering an investment in a given uh, country, jurisdiction, they will look at all available investment treaties that apply to that jurisdiction. And then they will consider whether if they don't already if they're not already in a jurisdiction with a good investment treaty, they will consider whether establishing an entity in one of the jurisdictions that does have an treaty protection is something that they can afford. There may be tax implications or a variety of other regulatory requirements. And actually, many investment treaties limit the extent to which a so-called holding company, a shelf company, a mailbox company, is covered. So it's actually a bit of an analysis that should be done. It's actually not very difficult to do. To pull up nowadays, it's pretty accessible to, you can look on the UNCTAD Investment Treaty Navigator, and very quickly you can see, okay, here are the 25, or maybe it's only 10 investment treaties that could be applicable. And you take a look at them and consider, is there any of them that potentially work for me? And sometimes the answer is, yeah, there are two or three really good options. And there are times that I've seen that the answer is, none of these really work for us. And it would require too much regulatory or tax cost or other costs that we're not prepared to take. And it's a business decision, right? How much risk are we going to take? How much confidence do you have in the jurisdiction?
It's something where, end of the day, one of the things that this kind of discussion reminds me about is that, in a way, what we're experiencing today is nothing revolutionarily new, in that there was always risk in energy, there was always risk in extractives. And one of the ways that the residual risk is something we can structure for is just by diversifying where it is that we are, to make sure that if I have at least the ability to run multiple projects, it would probably behoove me to run these projects in places that are not subject to the exact same risk in the exact same way. So,
Sure, and this is a luxury that a larger investor has, right? I think the greatest risk tends to be, I think, for the smaller or mid-size investor that might not have the luxury of doing that. But of course, that's true. Um, so Yeah, look, there all of these are trade-offs, right? Like everything
Hmm.
in life. These are trade-offs, and the best we can do is find ways to minimize risk and in that way lower the cost of the investment so that you're more likely to be able to afford multiple projects, or at least multiple projects, over time. That's true. But there's no question that those investors that have put all of their investment in one or two jurisdictions are, of course, more significantly exposed, and um, choose your jurisdiction wisely.
Let me just see if we have about, what, 2 or 3 minutes left. Um, I don't see another question in the Q&A, so I will just wait for just a second more to see if somebody might have a question for us. And if not, I might have a question to take us to the end. But let's see if there is another question that's coming in. So while we wait, so the thing that keeps me up um, at night in many ways as a lawyer and working in energy and international law is that there seems to be a lot of harumphing from every corner about how arbitration, investment treaties, generally the ability to bring claims against states is something that is deeply problematic, what have you. There's a lot of criticism out there, and there is a lot of uh, thunder um, about changing the system. I think in many ways it would be good to kind of remind people about what the value of it is. Like, what is it that we're getting out of predictability about a system in which, if you have a problem with a particular state, win or lose, you at least have a forum in which to bring it. You have a problem with a particular counterparty internationally in whatever part of the value chain you find yourself, there is some remedy available to you. That's something that it keeps me up at night in ways that there are people who are wanting to undermine what we've built over the last 50 years as a safety mechanism. And I'd be curious, uh, what's what would you if you had an elevator pitch, what's the value of that? Why do we need this? How do we protect it?
Well, governments are not infallible. And, it's very easy to see the award, oh, $200 million going to a private company. We don't seem to put the same spotlight on the confiscatory measure that was put in place, in the first place. If government takes, confiscates something, $500 million worth of private capital, they take something. We're not putting the same spotlight. These awards are just one side of a coin. And I think to evaluate, what's going on the one hand, you have a confiscatory measure of hundreds of millions of dollars that is creating a hole or is a problem, the result of perhaps abuse or just a decision to confiscate. And so we have to, recognize that governments are made of people. People are capable of abuse, corruption, confiscating property, and we need to have a way of dealing with these circumstances. Otherwise, we are saying to investors, your investment might be taken by abuse, by confiscation, simply because we change our mind. We are going to simply have less investment. So that's the answer is that we need to have protection of property if we want to encourage investment. And this is not even a function of what kind of market system you have, because you see China has more investment treaties, I think, than any other country currently on the planet. They don't want their investment confiscated or abused. I think this is a principle that we can all recognize the importance of. And that's basically, it's not more complicated than that. And that's what it's about.
With the investment volume we need to overcome the challenges we face today, the one thing we need is to make sure those investments can come and property is secure. That's absolutely right. Thank you so much for this wonderful conversation.